The U.S. Supreme Court has agreed to hear a case concerning President Donald Trump's power to fire a member of the Federal Trade Commission, FTC, a move that directly challenges nearly a century of legal precedent. The case, Trump v. Slaughter, stems from the president's attempt to remove Rebecca Slaughter, a Democratic commissioner, without cause. A law governing the FTC has historically stated that commissioners can only be removed for specific reasons, such as inefficiency, neglect of duty, or malfeasance. Lower courts initially sided with Slaughter, citing a landmark 1935 Supreme Court decision, Humphrey's Executor v. United States, which unanimously held that the president could not fire a commissioner of the then-nascent FTC simply for policy disagreements. By taking up this new case, the current court has signaled a willingness to re-examine the legal foundation of numerous independent agencies, from the Federal Reserve to the Consumer Product Safety Commission, and to redefine the balance of power between the executive and legislative branches. Analysis. Reasons for the challenge and potential consequences. The arguments for expanding presidential power are rooted in the unitary executive theory, a legal principle holding that the president must have complete, unfettered authority over the entire executive branch to properly fulfill his or her constitutional duty to take care that the laws be faithfully executed. Proponents of this view argue that the modern FTC has far more power and a different role than the agency described in the 1935 ruling, making the precedent outdated. They assert that the FTC's power to regulate antitrust, protect consumers, and enforce the law is a fundamentally executive function, and therefore its officials must be accountable to the chief executive. The government's Solicitor General has also argued that courts have no power to reinstate a wrongly fired official and can only award back pay. This suggests a broader challenge to the judiciary's ability to check executive power. Conversely, those who oppose unlimited presidential removal power, including Commissioner Slaughter and legal scholars, argue that the independence of these agencies is crucial for their mission. They contend that Congress created these multi-member, bipartisan commissions precisely to insulate their technical and expert decision-making from short-term political pressures. Overturning the precedent would, in their view, lead to seismic implications for the economy and governance. If a president can fire commissioners at will, decisions on critical matters like consumer safety, antitrust enforcement, or financial regulation could be based on partisan loyalty rather than expertise. This could lead to a cycle of regulatory instability with every new administration, undermining the very purpose of agencies designed to provide long-term stability and predictability. It would essentially place a president in charge of a headless fourth branch of government, as some critics have labeled the bureaucracy. Prediction and solutions. Legal analysts believe the Supreme Court's decision to temporarily allow Slaughter's firing is a strong indicator that the conservative majority is prepared to either overturn or significantly narrow the Humphrey's executor precedent. A ruling in favor of the president would likely grant the executive branch sweeping new authority to remove the heads of a wide range of independent agencies without cause. This would create a new era of governance where the president's policy agenda could be more aggressively pursued across the entire federal bureaucracy, but it would also jeopardize the nonpartisan, expert-driven missions of dozens of regulatory bodies. The decision could also impact the Federal Reserve, though the court has previously hinted that the Fed's unique structure might insulate it. If the court sides with the president, the primary solution would fall to Congress. The legislative branch could attempt to redesign agencies to be less susceptible to presidential influence, perhaps by limiting their executive power or by finding new ways to preserve their independence. However, this could prove to be a difficult and politically fraught process. In the absence of legislative action, the solution for these agencies would be to adapt, though it is unclear how they could maintain a reputation for impartiality if their leadership is subject to removal for political reasons. Conversely, if the court upholds the existing precedent, the status quo would be preserved, reaffirming the historical balance of power and the role of independent agencies in American governance. The case represents a pivotal moment that will redefine the administrative state, Regardless,